Welcome to our webinar about the new scrutiny of transatlantic M&A deals. This event is organized by the European American Chamber of Commerce, and my name is Yvonne Bendinger-Rothschild. I'm the Executive Director of the EACC New York. Companies are facing increased scrutiny on their exposure of social governance and social and governance-related risk, both from regulators as well as from various corporate stakeholders during M&A due diligence. Exposure risk includes human rights violations, not only by companies themselves, but also by their suppliers and partners, as well as stricter sanction and FCPA regimens, and increased enforcement by OFAC and its EU counterparts. Case law has been developed to hold companies accountable and to put pressure on companies to comply with regulations and to report their commitments to these larger societal goals. Our panel today will discuss the new compliance landscape and its effect on M&A deals, with a special focus on new transatlantic developments. Jim, can you take it from here? Our panelist, James Rosner, Managing Partner of Troutman Pepper and the President of EACC, is going to walk us through the program.
Well, thank you, Yvonne, and welcome to the seminar. I'm delighted to moderate this webinar and to have my partner Jordi Delano, my friend Bernard Cazeneuve from Paris, the firm of Augustin de Bouzy, and former Prime Minister of France, and a lawyer who spends a lot of time in advising clients on these very issues, as does Jordi, and also Stephanie Anderson, who's with Alex Partners and has a distinguished and storied career representing companies in jurisdictions that would be considered having risk and helping companies navigate those risks. So with that, I'm just going to open up with somewhat of a loaded question and ask the panelists. You have two companies competing to acquire a company based in France. And that company based in France owns natural resources in West Africa, and they want to do, hire both lawyers and advisors to do due diligence on that company. We have one company in Germany. We have one company in the U.S. Can you describe for us what that plan would be? I'll start with Bernard. What kind of plan would you advise the client to consider the risks that would be posed by acquiring this company with significant natural resources in West Africa and having acquired them over the years?
Thank you, James, dear friends. First of all, I would like to thank the European American Chamber of Commerce, James and Yvonne, for organizing this very interesting webinar, and all the panelists who are participating to this debate concerning compliance issues on M&A transaction on both sides of the Atlantic. Please forgive me in advance, because I will have to leave you at the end of my statement to join the funeral ceremony. And Alexandre Menucci, who is a very bright lawyer in our firm, will answer to your questions at the end of my purpose, if necessary. M&A deals present financial and legal risk, and for the acquiring company, those risks may be caused by certain reprehensible acts committed prior to the transfer by the target company. The increasing development of compliance obligations only reinforces the need for the acquiring company to conduct, prior to the merger and acquisition transaction, rigorous verification of the compliance procedures performed by the target company. Such verifications make it possible to mitigate the occurrence of significant risks, both from a criminal and administrative standpoint. The first risk is the transfer of the criminal liability of the acquiring company for acts committed by the target company prior to the acquisition. In the case of a merger, the French Cour de Cassation traditionally considered that since the operation caused the absorbed company to lose its legal existence, the absorbing company could not be held criminally liable for acts committed prior to the transfer. However, under the influence of the European courts, in a ruling of November 2020, the Court of Cassation has reserved its jurisprudence by ruling that the absorbing company could be held criminally liable for offenses committed by the absorbed company prior to the merger operation. Although this overruling only concerns M&A transaction that occurred after November 2020, this new state of the law entails main risk for company linked to the explosion of criminal proceedings in recent years. In the 20 last years, prosecutions for bribery have exploded, coming from the US, from some European countries, and from a cooperation between US and European authorities, such as in the Airbus case. Thanks to the famous Deferred Prosecution Agreement procedure, nicknamed DPA, the DOJ has imposed record sanctions on several European strategic companies, such as Alstom or Siemens, for example. Considering that if we want European prosecution authorities to be credible partners for the DOJ, the European countries should efficiently sanction by themselves domestic companies committing bribery. For this reason, the UK reinforced their settlement procedures through the 2010 Bribery Act, and France adopted the Sapin II law on December 2016, which created the French DPA named the CEGIP. Parallel prosecution initiated by states against companies are not regulated by international law. The principle is that states are in full control of criminal proceedings within their territories. This is because the prosecution of criminal offenses perpetrated on their territory is a sovereign prerogative which cannot be limited because of a previous action undertaken by another state. In other words, double jeopardies are no international application. Theoretically, due to the state of law, companies could be subject to consecutive prosecutions for the same offense in different countries and in different ways. These examples of non-coordinated multi-jurisdictional cases contribute to make companies more vulnerable by subjecting them to higher uncertainty because of concurrent and consecutive prosecutions. Therefore, the main question is how to coordinate the prosecutions initiated by different national authorities for the same facts. In fact, we can observe an increase of coordinated resolutions through transnational negotiated justice agreement. The first emblematic case dates to 2008, which involved Siemens prosecuted for violations of the FCPA and the corresponding German statute. More recently, there is the Airbus case, which involved a cooperation between the US, the UK, and French authorities. Further, this case showed that coordinated resolutions are also concerned the amount of the fine. Then, there is increased cooperation between French and US, and if necessary, other European authorities in sanctioning companies guilty of corruption. Therefore, we can see that preventing prosecution for bribery is crucial for acts committed by target companies before the transaction for the acquiring company. And this is, of course, very important for transactions concerning the African continent. This starts to be the same for alleged violations of human rights, and especially in countries in which women rights are not respected. Indeed, these recent years, under the pressure of the NGOs, the Tribunal of Paris has opened unprecedented investigations concerning companies accused of being accomplices of human rights violations. For example, building materials companies and some of its executives are being prosecuted for financing terrorism and complicity in crimes against humanity. They were allegedly implicated for the payment of several million euros to the Islamic States for the continued operation of the cement plant in Syria. This is a new issue that companies should carefully take into considering in M&A deals. The second risk relates to the administrative sanctions and the acquiring company may have to bear due to the target company's failure to comply with its compliance obligations. The Sapin II law created an obligation to prevent corruption for French companies and groups whose parent company is headquartered in France, exceeding certain thresholds, 500 employees and 100 million euros of turnover. It imposes these companies to implement strong compliance programs, notably to keep tracks of suppliers and intermediaries. The French Anti-Corruption Agency was set up to enforce this obligation and can sanction companies which do not comply to this obligation, imposing a fine up to 1 million euros. Therefore, the acquiring company could be sanctioned by the French Anti-Corruption Agency because the target company's failure to implement the obligations of the Sapin II Act prior to the transfer transaction. It can expose the company to a fine and to reputational risk. Similarly, in the field of sanctions, the acquiring companies are also exposed to a strong risk in M&A transactions due to actions of target companies. Due to the war in Ukraine, sanction regimes have expanded considerably. It is therefore fundamental for a company in the context of an M&A transaction to verify a certain number of points: that the target company is not being prosecuted, either administratively or criminally by OFAC or by the relevant European authorities violating sanction regimes, that the target company's activity does not expose it to such proceedings. If this is the case, to verify the mechanisms put in place to avoid violation of the sanctions regime. Then it is absolutely necessary to conduct due diligence, to avoid being involved in criminal and administrative procedures, to prevent reputational damage. You can imagine our allegation of human rights violation by the acquired company and failure to evaluate the risk violations during acquisition risks to harm the reputation of the acquiring company, to avoid negative impact on the share price, negative impact on credit rating, and litigation-related cost.
Hey, Bernard, sorry. Can we just take a minute just to get a sense from Stephanie of what kind of due diligence she would advise a company to take to understand and to really engage and identify the risks? And then maybe Jordi can have a little bit of discussion on what do we do in the face of those risks.
Sure. So the first thing I would want to know is what is the history of the company in terms of what is their history? What have they found? Have they found bribery? Have they found violations of human rights acts and such? And I will tell you, if they say no, I would be very suspicious, because this is a company that's operating in West Africa. It's already a highly corrupt regime. And then the industry, an extraction company, is always just a target for corruption or in other things, just because of the amount of money they bring in and such. So I would ask about the history. There may be, in terms of whether or not there had been things that they found, I would feel better if they found they had found issues and they fixed them. Like I said, then if they didn't find issues, that makes me think they didn't look. I would want to know what remediation they did. What things did they change after they found any issues? I would really want to vet and understand how they vet their third parties. How do they come to understand whether or not government officials are involved, whether or not there's other risks? I'd want to understand, do they on occasion do audits? Do they go out and visit those? I think a surprise audit is always a good idea. Do they train their third parties? Do they make them do certifications as well? And then finally, I want to know about their control environment. For example, if you're doing a lot of work in West Africa, do you have somebody who's responsible for monitoring that compliance environment for making sure that it's effective? And I'd want to know how automated that is and what tools they're going to use. So at a high level, that is what I would want to know going into the due diligence.
So, Jordy, now you found an issue, and you found, it's likely to have existed, but you still want to buy the company. Is it a mistake to buy the company? Is there a way to buy the company and mitigate that risk? And Alexandra, I'll have ask you the same question from the standpoint of a European company.
Thanks, Jim. Let me, if I can, step back for one moment and kind of set the stage. Your initial question was, what do we want to do? What do we want to look at? And I think what I like to advise everybody, in partially self-interest and then partial because it is I find to be the most beneficial. You need to involve compliance and ethics specialists from an early stage, from the beginning. All too often, folks like Stephanie, myself, we get called to the table too far along in the process to really make an impact. And so from an early assessment standpoint, you should, acquiring companies need to involve the specialists to be able to evaluate the target company's risk, not just anti-corruption risk, but as Bernard was saying, all other sorts of risks that would want to be evaluated and taken into account. Now, from an industry perspective, this West African extraction company is in a high-risk industry. From a country, from an area, geographic risk area, it's in a high-risk area. So that will inform what I call step two, which is really developing a due diligence plan that will carry the acquiring company all the way through. And that is, in order to learn many of the things that Stephanie just noted. But now getting to your point, what happens when you find a violation has occurred, some sort of a corruption violation or something that causes the lawyers in the room to cringe when they hear that a company's business model was, or a company was involved in certain practices? Well, it does not have to kill the deal, certainly not. There are steps that DOJ has put forth that identify how companies can move forward. And really, this is why you develop a comprehensive due diligence plan, what to do in the event of these violations being discovered. So if a violation is discovered, the first question is to the target company: was that violation disclosed? How did the company deal with the violation? Are there compliance procedures in place to deal with it? Was this the first that the company had learned of it? And really, the decision has to be made from the acquiring company side is how they are going to move forward with government authorities now that they know that this has occurred, right? So it could be taken into the valuation of the company and lower the valuation by however much the acquiring company believes it will cost them to disclose the violation, remediate, the investigation cost that may come into it, or you can require the target company to make that disclosure. So there's different avenues, depending on the level of violation and how pervasive the misconduct is, that needs to be taken into consideration. I will say, this happens all the time, Jim. Recently there was a fairly substantial, I say recently in the past 2 years, a fairly substantial FCPA resolution. I think it was the first of the Biden administration the AMEC Foster Wheeler case, that involved two acquisitions that occurred during a period from when the alleged misconduct took place to when the enforcement action occurred. First, Foster Wheeler was a Swiss company that was acquired by a British oil and energy engineering firm in 2014. Then another British company acquired AMEC Foster Wheeler in 2017. At the time of both acquisitions, it was known to the Foster Wheeler board that there was corruption, corrupt activity taking place, and either it was not revealed as part of the due diligence, or it was not appropriately taken into the valuation by the ultimate company. And sure enough, the ultimate acquiring company, the Wood Group, ended up paying a substantial amount of money to various enforcement authorities for the acts of the standalone Foster Wheeler years prior. So it can get very expensive.
And Bernard, from the French point of view, how would you deal with a known risk or known event that occurred in the target company? Would you advise the company not to do the acquisition, or would you go forward with the acquisition? And are there mitigation steps that you can take?
Now, it's very difficult to answer this question without looking precisely at every case we are confronted to. But if I look at the different dossiers we have to look after during the past, and especially concerning companies who are involved in Africa with a high level of corruption and problems concerning human rights, and it regards also to the new rules the French anti-corruption authority wants the companies to implement. I would say that even if there is a risk, you can conclude the deal, but if you want to conclude the deal when you are confronted to a risk, you are first of all to be sure that the involvement of the management of the acquiring company will be strong, and that the manager of the acquiring company will be in situation to look very carefully at the process implemented in the target company, first point. And the French anti-corruption agency is looking very carefully, and it's also the case with the PNF when there is violations of rules, if the involvement of the management was strong enough to avoid problems in the future. Second point, if you are confronted to a risk due especially to violations concerning the past of the target, you have to implement a mitigation plan, that is to say, evaluating the reasons of the violation for the past, and being able to implement all kinds of process to be sure that the violation will not happen once again. And sometimes when the violation is due to the willingness of the manager of the target company to obtain a certain number of markets and so on, you have to organize the process within the target company to avoid such difficulties in the future. If you are able to prove that you have done all those efforts, you can, of course, be in situation of acquiring the target.
So, Stephanie, when you've done the pre-acquisition due diligence and you've identified stuff, what kind of steps do you put in post-acquisition so you can ensure compliance and ensure that compliance is not just within the hands of the same management that committed the act prior to the acquisition?
Sure. Once we get more information, once we're able to be, once we're able to see data and really be able to dig into policies and understand the people and the processes and such, typically what we would do is put together a heat map. And so looking at a company in West Africa, we would be very focused on all the different places that they touched government officials, There would be certain that we viewed as higher risk just based on our experience in working. We've done a lot in West Africa. We would really want to do some, probably starting with just some desk analysis. We would want to gather some data and do some quick audits and sampling to get a sense for the risks that we're seeing. And then based on what we see, we may end up deciding that we want to do further work. For example, we may want to we may want to try to audit, for example, some of the third parties. Or we may even, if we get really concerned, we may even want to do some more deep investigation to just understand who is behind the third parties and whether or not they actually do work. We would also get to work making sure to bolster whatever the compliance organization is. For one, making sure that there's someone who's monitoring the subsidiary and its touch points with third parties and government officials. And we would want to also bolster their processes as well.
Jim, if I could jump in and add to what Stephanie just mentioned, so much of what we focus on is the pre-acquisition due diligence, but from a DOJ perspective, post-acquisition conduct is equally, if not more important. And so, pre-acquisition, there would certainly all the parties would be evaluating whether there were appropriate or adequate policies and procedures in place, not only within the acquired or the target company, but also within the acquiring company. Post-acquisition, if DOJ were examining, they would want to know how quickly the acquiring company rolled out its policies and procedures to the newly acquired company, how quickly and effectively directors, officers, employees may have been trained on that policy. And then, as Stephanie said, conduct very targeted audits, specifically where you've already identified misconduct, to make sure that conduct is no longer taking place. Ultimately, there will also have to be a decision on whether it's pre-acquisition or post, whether to disclose this misconduct and what impact that's going to have with the relevant enforcement authorities. But very important that especially the period 180 days post closing is a period that is absolutely going to be under scrutiny by the regulators and the enforcement authorities in the U.S.
So that brings up another point, Jordy. I mean, recently, the Department of Justice has announced a new policy relative to self-disclosure of acts, whether the FCPA or related, criminal acts, and self-disclosure has great incentives. But at the same time, self-disclosure risks disclosure enforcement by another country. As Bernard had said, they're not necessarily coordinated. So first, can you talk about the new policy and what its effect is? And then let's have a discussion with Alexandra on is there a way to coordinate these policies?
Sure. The new policy is really an expansion of a policy that had been in place for some time. What's known under what's called the corporate enforcement policy, or a series of factors that DOJ will consider when determining how to move forward. And the newest version of it simply expanded it to apply to all corporate entities, not just FCPA corporate enforcement. But under this policy, the DOJ has created a program that that seeks to incentivize voluntary self-disclosure by companies. And at the end of the road, at the carrot, I suppose, for this conduct would be to decline any sort of criminal prosecution if certain factors are met. 1, the company self-discloses. 2, full and complete cooperation by the company in the investigation. 3, timely remediation of the misconduct. And then 4th, disgorgement or payment of any ill-gotten gains. We can debate in another panel whether self-disclosure is appropriate, or whether that speculative benefit is one that that is good. I think in certain cases it may be absolutely the proper course of conduct for a company. But your point that whether this has increased a company's risk of being prosecuted by another authority is well taken, and it's one that any company that is ever in a position to contemplate self-disclosure must evaluate as well. If a company self-discloses to the Department of Justice, they must know that the resolution will be made public. All declinations, even if they get the benefits that were promised under this policy, they will be made public by the DOJ. If the result is not a declination, but rather an enforcement action, that will also be made public. Now, the trend you referenced and Bernard referenced about increased cooperation among different foreign governments and foreign enforcement authorities is absolutely correct. This is a trend that began a few years back and has only increased. For the longest time, it was the FCPA and the UK Bribery Act, which were the only games in town. And many other countries have enacted anti-corruption legislation, but really it's been their enforcement mechanisms that have taken some time to catch up. The case that Bernard referenced, the Airbus case, is a great example of such cooperation. That case involved both UK and French joint investigation and a parallel US investigation, and a resolution that was a coordinated one. But in that situation, there was a self-disclosure to one of those authorities and not to some of the others. So DOJ, for example, did not give Airbus self-disclosure credit. But it's not just the big countries. It's not just the countries with more well-staffed or sophisticated enforcement bodies. Last month, there was a fairly substantial criminal resolution or FCPA resolution with ABB, which is a Swiss company, and that resolution involved the U.S., the South African authorities, and the Swiss authorities. And so, what we're seeing is this trend continuing, and that's not going to go away as the enforcement mechanisms in a lot of these countries continue to get stronger. One point that Bernard made about the cost and countries being able to prosecute and impose penalties on their own or on companies is also very well taken. But I think one of the things that we must keep in mind as well is DOJ knows this. DOJ is very well aware that other countries have the jurisdiction, the ability, and will in fact prosecute companies for the same conduct that DOJ wishes to prosecute. And that's why they came out with a policy a few years back called the no piling on policy. And this is effectively a policy that is meant to discourage imposing duplicative penalties, duplicative fines for the same misconduct. That Airbus case is another example of this policy in effect, knowing that the French and the UK authorities would be also prosecuting the corrupt acts. U.S. imposed a penalty of over $2 billion, but then credited the payments that were being made to the other authorities, which are over 1.8 billion. So, I say that only because any company that gets to the point where they are going to contemplate self-disclosing to any enforcement authority must consider global resolutions with other enforcement authorities from the beginning.
So on the self-disclosure, just going back to self-disclosure, some say that it's inevitable because of whistleblowers and the incentives given to whistleblowers that you better self-disclose, because if a whistleblower beats you to the punch, you don't get the benefit of this new program or this program.
And oftentimes that's the impetus for the self-disclosure. It's really knowledge of a whistleblower or fear that a whistleblower is going to let the cat out of the bag first. when I was in the Department of Justice, in fact, that is on various occasions, we received self-disclosures from companies because they feared that a whistleblower was going to alert the government authorities as to certain conduct. And sometimes it's a whistleblower in one country with respect to one activity that leads to the self-disclosure on a different scale. So it is a risk. It is a risk, and certainly the bigger the company and the more pervasive the misconduct, the higher the risk that a whistleblower may alert the relevant authorities. On the other hand, if the conduct is contained, remediated, and the company has a high risk tolerance, then a self-disclosure may not be the appropriate course of conduct. I mean, a self-disclosure does promise a very real benefit at the end of the road, which is a declination. But to get to that point, it requires full, what they deem full and complete cooperation is a pretty hefty requirement on companies, and the investigative costs that go into that cooperation can sometimes be more expensive than the possible outcomes. And so really, it's impossible to say self-disclosure is the right way to go or the wrong way to go. It really is fact dependent on the misconduct at issue, and the company that we're dealing with.
Alexander, is there a self-disclosure regime in France or Europe?
Yeah. Actually, the self-disclosure regime in France is really interesting too, because the FAA, so the French Anti-Corruption Agency, and the PNF, which is the French DOJ, if you want, the Parquet National Financier, just published their new guidelines of this year about this question, and about the question of when can we conclude a settlement, meaning a CGIP in France, which is the French DPA. And the self-disclosure is one of the factors first to conclude a settlement, because the settlement is not automatic, like maybe contrary to the US, the conclusion of settlement for criminal acts is not like in our French culture. It's something quite new, because we opened this kind of settlements in 2016, so not even 10 years ago. So it's something really new. So to be credited for a settlement, you need to prove that you cooperate. And one way to cooperate, of course, it's self-disclosure. It's of course not the only way. You can always conclude a settlement if you don't self-disclose the fact, but if you just cooperate to the investigation once it's opened. But the self-disclosure is one of the factors for the conclusion of the settlement, but it's also a minoring factor for the amount of the fine. And this is very interesting, because we can see in the new guidelines that self-disclosure is reinforced as a minoring factor for the fine. And the French Anti-Corruption Agency and the PNF is really evaluating safe disclosure. But what is very interesting, in my opinion, it's the way to decide how to self-disclose, which process to fully understand that self-disclosure is a good decision. And of course, it's our role as lawyers to make clear internal investigation, to understand if it's worth it or not to disclose, because there is a criminal act or there is not a criminal act. And this is really interesting to understand how to conduct this internal investigation, because in France is also a new practice to investigate on this kind of facts internally before disclosing to the PNF.
Stephanie, did you have something to add here?
Yeah, I was going to add really on what Jordi was saying in terms of the road to declination. We've had really good experience working with companies that had found something scary after acquisition. I'll give you an example. It was actually a West African company. After acquisition, the acquiring company discovered that it appeared the target in West Africa had paid bribes in order to get its business license just to operate in that industry. We were engaged to help them investigate it and also help them put together the compliance program. And it ended up to be not just bribery of high-ranking government officials for the license, but even smaller things like allowing the police to come fill up all of their personal cars with gas, from paying, one of my favorite one was paying the port workers with goats in order to allow them to offload their equipment and prevent delays in getting equipment that they critically needed. But in that particular case and in others, when we worked with the company just to quickly investigate it, quickly be able to put arms around the issues, the companies in those cases also put somebody on the ground who was monitoring payments that were going out from that point forward, to make sure there wasn't any evidence that those payments were going to be used for corrupt purposes. And just really working with them to clean up their compliance program, we were able to go back to the government and report all the work. We were able to report the company's progress and status in their remediation efforts, and they were able to get a declination. So they were able to get a declination, and they also avoided successor liability, which was very important. So I think the thing I want to say is it's, if you do find something even before the acquisition and certainly after the acquisition, if you move quickly, there's been a lot of good success in avoiding being convicted and avoiding being blamed.
So, bribery, obviously, FCPA, everybody knows it. I can even spell it. It's, it's on everybody's agenda, but there's more than that. So, for example, in the US, you have the Erger Forced Labor Protection Act. France, you have the responsibility to investigate your suppliers for human rights violations and similar. And for the three of you, really, how do you deal with those kinds of risks when you're acquiring a company and you're looking down the supply chain, which can go fairly deep? Why don't we start with you, Alexander, because of your...
Yeah, actually in France, we have a new statute dating from 2017 about the duty of diligence for companies to verify all the supply chain of their suppliers, intermediaries, and this, about violation of human rights, violation of labor law statutes, and violation of environment. So this is really very, very concerning for companies. And when you add that the Tribunal of Paris has opened many investigations, something like 10 investigations about concerning companies and some of their directors for a complicity of crime against humanity and war crime, because companies, for example, supplied some regime without knowing, of course, that they committed crime, and they are prosecuted today. So companies are of course really concerned about this problem, and for us as lawyers is also a concerning problem to check before the M&A that the company is not prosecuted, of course, and once we can see that prosecuted or not, to verify if the mechanism I put in place to defend the company before the tribunal, of course, during the prosecution, and also to check if the mechanism are put in place to prevent this kind of act to be reconducted, for sure.
Yeah, because as I understand it, that it's not only internal whistleblowers that are bringing this to the attention of authorities; it's the NGOs.
NGOs
basically are front and center at this and investigating this pretty much constantly and looking for a culpable company.
Yeah, exactly. NGOs are all these investigations are not all, but many are launched by NGOs actually. So yeah.
Jim, I'll add to what Alexander just said. In the US, there is a relatively newer regulation when you reference the Uyghur Forced Labor Prevention Act, but prohibitions and laws against forced labor and using contracting with folks that are known to use forced labor or child labor have been around for quite some time. And from a diligence standpoint, it has always involved verifying your suppliers. The challenge that companies are facing in the face of this new law is that it creates something that has not been in prior legislation. It creates a rebuttable presumption that if certain products come from a certain region in China, the Xinjiang Autonomous or Uyghur Autonomous Region, then they are presumed to have been made with forced labor or child labor. And in order to rebut that presumption, companies must be in a position to be able to trace their supply chain all the way down. If you're the original purchaser, then perhaps easy, but oftentimes companies are third, fourth, fifth level removed, and that becomes increasingly difficult to do. What it has forced folks to do is really evaluate how they're going to trace that supply chain and make sure that business partners that they engage with are able to do the same for their inputs, for their suppliers.
So as I understand it, other than the Uyghur Forced Labor Protection Act, that most of the liability to a U.S. company for supply chain issues like forced labor is reputational as opposed to criminal. Is that, do I understand that correctly?
Well, reputational, certainly there can be criminal repercussions, but oftentimes where it really hurts a company is your product is going to be detained. It's not going to be allowed in the country, and you're going to be left without it, right? And so, just to give you some idea of the types of products that are known to emanate from that region: tomatoes, cotton, polysilicon, silica, solar panels, which is an ingredient or an input in the manufacturing of solar panels. There's very many types of products that can come out of that area, and so it's critical that companies conduct this due diligence on the front end. I'll tell you,
if it comes from a different region, it comes from Bangladesh, it comes from parts of Indonesia, but it's found to be forced labor. Is there a detention
yes.
risk?
If it's found to be forced labor, there won't be a presumption if it's not coming from that area. I will say the Canadian authorities have a similar regulation, and they found a certain entity was moving tomatoes from China to Indonesia and repackaging them before shipping them out. Right. So again, this is an example of the need to be able to trace your supply chain all the way to the source.
So Stephanie, how would you go about putting up a plan to help somebody work through 5, 6, 7 layers of supply chain to ascertain its source?
So, typically we would put together some type of once again, really a heat map. Jordy spoke on some of the things that have a higher risk of having human rights violations. So we would focus on the suppliers that were at higher risk. I mean, I think in terms of how we would go about understanding, we'd want to understand how the company vetted their third-party suppliers, how they monitored them. We'd want to understand if they're training them, if they're requiring certification on at least an annual basis, that they understand the laws that they have to comply to, both U.S., French, or wherever in the world they happen to be, or wherever in the world there's some nexus. We would, once again, want to also understand, is there any sort of a history in terms of is there a history of noncompliance? If so, what has the company done to fix that? And to the extent they're not doing any sort of audits, we would recommend that they make sure they audit to make sure that they have audit rights in contracts. In fact, this is something I'll just dwell on for a moment. It is sometimes very difficult for us to do our work just because audit rights are not included in contracts. So now that I have a bunch of attorneys here, I would say make sure that your suppliers and your vendors and your agents all have audit rights in their contracts so that you have the ability to go out and check. So it'd be more or less the same type of things that we would do for FCPA that we would also do for HR, for human rights or any sort of environmental issue as well.
And in France, Alexander, what's the protocol for ascertaining your supply chain and dealing with this new legislation?
Yeah, actually, it's like Stephanie just said, it's exactly the same that for compliance issue we are checking like by questionnaire, things that we can see from the target companies. But maybe as you may have in the US, we sometimes have some difficulties to obtain some information from the target company. That's why before the signing, we try to have a protocol for them to release the necessary information for us. So this is also for something very, very important, but the process is somehow the same than in the US. But there is something also very important that will happening in France and in Europe in the next few weeks, few months. It's the adoption of a European directive, so which will be applied in all the European Union about the duty of diligence. And just for you to know, at the beginning of the discussions, at the beginning of the negotiation on this text, it was provided that companies will have to audit not only their suppliers, but also their clients. So it means that when you are a company and you are selling products around the world, you will have to check if your clients is not someone who use your product in a way that it's contrary to labor law statute, to human rights, and this. We understand that the European Union is evolving on this provision, but many people are in favor. We somehow trying to understand how it's possible to put this in place, but it's in the discussion right now, actually.
So there was a question from the audience that basically goes back to one of the early M&As involving the church and basically misusing the preaching of its gospel, which ultimately, I guess in hindsight, there was an overreaction. Are there laws that you view as really an overreaction to a single issue that need to be addressed and remedied today, or are we still in the development of regimes that ensure compliance in a sensible way? In other words, have we gone too far?
I'll volunteer, Mike. I don't think we've gone too far yet. I think corruption in particular is, for anybody who's lived in a country with high incidence of corruption, is devastating to the people of the country, to the citizens. I think it is viewed that way by governments, and the more that the increasing trend where governments are adding to their enforcement mechanisms is going to bring noticeable change. I do believe that. I think companies, the larger they get, the more sophisticated they get, are being required by governments to enact policies that are sensible and reasonable to prevent this from going on, to be good corporate citizens. And in my experience, at least with my clients, that's what most companies want to do. They want to be able to comply. And so whether it's too far, I think I understood your question, Jim. I think I'm happy to see more countries beefing up their enforcement mechanisms. I'm happy to see more coordination among governments. I think perhaps you could answer the question of whether so many governments should be involved in a potential resolution, right? That could be perhaps going too far, but like I said, it used to be just the UK and the US that were very active in this space, and now many more countries are involved and are proud of the enforcement actions that they take. And so if that means punishing a company for the acts of another, of a company that it acquired, that's unfortunate that it has to happen, but I think it's all done with the best intention to enact change.
Yeah, I would add, I lived in Russia for 3 years from 95 to 97. I was advising multinationals and private equity buying Russian companies. And then I've lived in Kuwait and Mexico. Like Jordi, I don't think we've gone too far. I mean, corruption causes a lot of income inequality. It stifles businesses and business owners from being able to optimize their businesses. So, in addition to causing extra costs for a company that's paying for corruption or for other things. So certainly in my view too, I think it's very important to tap down on corruption and to do our part, because it results in a very inefficient redistribution of money to just a few corrupt people within a government, versus it really is sort of stealing resources from the citizens, in my view, based on the experiences that I've had. And it's also just extremely inefficient way to try to live your life if you have to pay bribes for everything you need.
Okay, so we're coming on the top of the hour, and I really appreciate the dialogue that we've had so far. If each of you have kind of one closing comment, relative to acquisitions in high risk areas, what's one takeaway for this audience to learn and to focus on in looking at opportunities?
My sense, I said it earlier, I'll say it again. I think it is critically important that the specialists get involved very early on in any potential merger or acquisition, to be able to fully complete their investigation and properly advise. The trend of successor liability is not going away, and companies should be aware of that.
Great. Stephanie?
I would echo Jordi, and then I'd say, once you've made an acquisition, to the extent that you do find some impropriety, to go ahead and fully investigate that and make sure it's fully remediated to protect the company.
Alexandra?
Yeah, I completely agree with both of you. I think it's a way for companies to protect themselves from bad surprise they could have later on. Yeah.
Well, with that, I just want to thank Jordi, Stephanie, Alexander, and give my thanks to Bernard. I thought it was a lively discussion. Hopefully, the participants, take something that back to their company, and obviously both Jordi and his team, and Bernard and his team, as well as Stephanie and her team, are all available to help should there be an acquisition that would mandate that kind of diligence.
Thank you.
Thank you, Jim.
Thank you, Jim.
So this concludes today's webinar, and a quick reminder, if you're an EACC member and you would like to connect with any of the other participants, as well as Jim just said with the speakers, if you have additional questions, please reach out to us and we were happy to connect you. Looking ahead, we have a couple of really interesting programs coming up. We are organizing a private lunch with the head of the EU's DG Trade. We have a program on supply chain risk and resilience, new developments in labor and immigration, ESG factors in M&A transactions, and the EU's DORA regulation. We will post all of these programs on the EICC website, along with a recording of this program. And I wish you the wonderful rest of the day. Thank you so much.